And what's going on, everybody? This is Vinny Maletti with Maletti Law, the strongest name in law. This video was actually video number 3. Well, first of all, before I even get started, because you know how I roll, because I always forget, please click on that subscribe button on the YouTube page, or you can go to my website at www.malettilaw.com. That's www.malettilaw.com. Join the newsletter, be in the know, always be up to speed when it comes to new content being produced, new videos, new blogs, new everything going out. I mean, law firms constantly got a lot of things moving. So here we are. So this is video number 3 as part of what I'm calling the L&E Series, the fusion of law and entertainment, the fusion of law and entertainment over here at Maletti Law, the L&E Series. This is episode number 3. This is video number 3. We're still going through, just by way of quick backdrop one more time in case you forgot. Remember, this is part of our new program in which we're beginning to introduce a lot of entertainment law, a lot of entertainment law issues. Again, I didn't realize that the firm was really getting so many hits and queries about it. I got so caught up in like nurses and stuff and, suing the government that I'm not paying attention to what the market's asking for. So this is part of our series to deliver to you gals and guys in the industry what you're looking for. You're looking for content. You want to know more about you want to know about entertainment law. You want to know about certain things. I mean, because at the end of the day, I guess we seem to get a lot of traffic and queries from, entertainers, from artists, from labels, from brands, producers, marketing companies, etc. So in the last video, we had mentioned, that there were unique properties about the types of contracts that come in entertainment law, right? So entertainment law, you remember, entertainment law, you're looking at 3 things. You're looking at contractual law, you're looking at intellectual property kind of related issues, and you're looking at regulatory issues, okay? So the contract issues with entertainment law are unique simply because when it comes to this area of the business, there's a lot of uncertainty. Things change daily. Things change left and right. Tomorrow morning, your client, let's say you're representing an agent or something. Let's say you're representing, an artist. Tomorrow morning, the artist could be given one situation, next week another situation. And while you're still going back and forth on the preliminary matters, a lot of things have already developed. So we're still going through, kind of like that kind of that uniqueness of the contracts in entertainment law. So today we're going to walk through just 3 other little concepts. First we're going to talk about why contracts are like this, why there's this, why they're so fluid, why they're so dynamic. Contract is about expectations, right? So even when you look at how contract damages are, expectation damages, reliance damages, you have a contract, there are rules and laws in place, and you're supposed to, be able to have reliance on these things. You're supposed to be able to, what's what I'm looking for? You're supposed to be able to predict what the future is going to look like based on your contract, right? That's what you're supposed to be able to do. So, but with in this industry, it's a little bit different in this industry, So it's like I said, this has a very unique properties industry of like being so dynamic and things changing at such a fluid and rapid pace that it changes even beyond the time it takes to prepare these contracts. And again, A-type personalities, right? Artists, labels, brands, business owners, marketing agents, A-type personalities. So in this industry, when it comes to entertainment, in this industry, contracts actually reflect uncertainty. That concept is very different than any other industry. In the entertainment industry, you have a contract because it's so uncertain you need a contract. You could formalize anything else in this world. In any other industry you go to, whether it be e-commerce, corporate dynamics, whatever, transactional work, whatever, insurance, contracts are seen as, they're seen as being more formalities. They're seen as being better preparation, risk mitigation, risk management. Here, contracts cause uncertainty. It's crazy as that sounds, right? So, and this is just simply because, these type of contracts don't follow your standard process. Remember, these contracts, there's a lot of oral discussions. We spoke about it before. A lot of oral discussions, a lot of unsigned writings and a lot of unsigned documents, unsigned writings, contracts on napkins, contracts on tissues, deal memos, the industry's version of a letter of intent. So they don't follow the typical contract formation process. So, that's reflective of the fact that contracts are very uncertain in this industry. They reflect a high degree of uncertainty. So, in the law, we have something called Promissory Estoppel, right? So, Promissory estoppel is when a party you're negotiating with has a reasonable expectation of something, and then you kind of like renege on it or whatever the case is, and essentially that person has been estopped from moving forward with, from changing the situation. That party's been, estopped from avoiding this particular thing that they were supposed to be doing. So promissory estoppel is a big thing here. You're always concerned with promissory estoppel. So, what this industry needs to, what happens a lot in this industry, it takes a substantial amount of energy to, get people to get to the table and put things in writing. Okay, so a lot of times, again, we've mentioned oral discussions, on-site writings, deal memos, but can we get you to a formal document, right? And that's very difficult sometimes. And again, it's because of the dynamic nature of this industry. It's because of the A-type personalities in this industry. So again, you hope to plan for this with the deal memo, but a lot of times, to get there, to get there, it's a struggle sometimes, right? So remember, the deal memo is this industry's version of a letter of intent. So just a few pointers with the deal, just a few pointers to try to avoid contract formation issues, to try to avoid problems, right? So I have actually here, I've outlined, my outline is scrap notes. I've outlined like kind of like 7 ideas that we constantly have to keep touching on. The first idea to avoid the contract formation problems, to avoid instances of promissory estoppel, to avoid instances of forbearance and stuff like this. The first thing I want to point out is you got to try to get something signed and in writing. Again, whether it be a deal memo that you agree to, that it's bound, whether it's just some kind of documentation to agree to something, right? Because you need to have consistency, because it's very hard to contract about things without consistency, especially in an industry that's incredibly dynamic. So, 7 items. The first item is you want to try to get a contract in writing, or get some kind of writing signed and that parties agree to be bound. Tremendously, it's a lot more difficult than you think. And the negotiations sometimes go on and on and on. I don't know how else to explain it. You could try to tell your client you're an hourly rate, but they don't care. And they'll just fight you on your bill too, so it's fine. So, also, you want to point out, so the first advice I would say is try to get something in writing, anything with a signature. The second suggestion I would give is you need to state specifically on that writing, as long as you got it signed, specifically what exactly is binding, right? What terms are going to be bound, when we're going to come back to the table, what's compensation going to look like, whatever the case is, right? So that's the second suggestion I would say. State specifically in there what specifically is binding. The third item I would tell you to really focus on is whatever is specifically binding, make sure you properly detail, in particular, the terms that are bargained. Okay, so you have a back and forth. Again, we'd mentioned, compensation. We had mentioned the term, right? But just make sure that's with specificity, that what's been bargained, that this is, we've agreed to bargain on these terms. We've agreed that this is the right and proper way to do it. And, again, certainty. Right? Some kind of certainty in a world, in an industry that's completely uncertain, right? So the third part's going to be make sure you have adequate details, and you really specify particularly bargain terms. It's very important. The fourth item, and this is just a practice tip to help all of you. Reference outside terms, reference outside contracts, reference previous deals, reference whatever you could reference, because this is extremely helpful in terms of having long-term consistency. You have labels, you have record deals, you have artists, and again, dynamic nature of this entire thing. In the previous video, we mentioned recitals. Recitals was these contracts focus heavily on recitals, but generally when it comes to kind of like I believe they call like probate, the probate rule, I don't know, I can't remember, I'm not remembering my 1L contract terms right now, but generally outside writings, you kind of like, you want to look to them just to support the existing agreement. You don't really look to them to like push. Parole evidence, not probate, the parole evidence rule, something like this, right? So outside writings, previous dealings, they all supposed to lead to an interpretation to support, not really to fight. But in these contracts, because you have so much dynamic nature, so much change day by day, you want to try to reference these things as much as if you could, cross-reference in your writing, previous deals, previous contracts, previous, that create like a trail so you can be able to adequately interpret down the road when necessary, what needs to be done. If you are unable, this is going to be my fifth concept to you. If you are unable to come to some kind of agreement with somebody, or unable to come to some kind of term that you know you should detail now, come to an agreement on how you're going to formulate that. So, perfect example, compensation. If you and your buddy cannot, if you and your, you and your artist can't come to some kind of conclusion right now on how you want to run compensation, come with some kind of formulaic process. Agree to a formula in which you're going to be able to address compensation issues. You don't have to agree to the number. Agree to just the formula on how you get there. Get something, because again, you don't want the debate to go on forever. Otherwise, you're never going to get into a contract with them. So the fifth point I would give you is to consider, if you're unable to come up with specific terms, things like compensation, come up with a formula. Agree to at least how you're going to approach that formula and the method you're going to use to formulate the process. A-type personalities. Okay, this is pointer number 6. Short. Keep this contract short. You will. I'm telling you, A-type personalities. You will not get them to the table for very long. They'll sit there and negotiate all day. They'll sit there and fight with you back and forth all day. But if you think they paid attention to that document more than 20 minutes, it's not going to happen, right? So you want to make sure you keep the contract concise, to the point, hit key terms, be as specific as you can be, but try to keep the contract relatively short. Keep key terms, whatever you could do. Again, I mentioned citing previous agreements. That might be a helpful way. Maybe you want to say incorporated by reference. This agreement, maybe you had a consistent artist overall. Maybe you got an artist for a label, and with every album, they want something new. With every song, they want something new. Consistency. Keep it track, but keep the existing contract as short as you can, but as detailed as you can. Referencing others, that's fine. So the sixth point I'm giving you, try to keep these things relatively short, shorter than any kind of standard transactional documents. I'm notoriously known in e-commerce for 9 to 11 pages. 8 pages is generally like, I feel comfortable about 8 pages with a signature, right? So let's say I'm notorious between 8 and 11 pages. I like these to be like 4 pages, And the final point I'm gonna make out, and I'm gonna stress this because I'd also mentioned this in the previous video, but I just want to make it very clear. Do not be afraid to use recitals to cite the intention of the contract. Intent and reliance. The parties want to do this. The parties, their objective is this. Do not be afraid to cite recitals. Recital the shit out of this document, because it's going to help you later on when you're going to inherently have the debate, because things are going to change a million times, because the artist is going to come across some cool stuff. There's going to be maybe some new. The label's going to have some new, maybe another performing artist, and artists are going to compete with each other. Whatever the case is, artists are going to, there's going to be some synergy, and then there's going to be some departure. So I mean, like, don't be shy with recitals. You don't sound stupid for writing them. It's not, you don't sound like unintelligent, like you need fancy legal terms. Don't be afraid to write your recitals. Don't be afraid to recite, and be clear on what the purpose of this contract is supposed to be. So, one quick run through with this one, the 7 pointers that I just kind of like scratch out here. One, get something in writing, whatever it is, get something in writing, number 1. Number 2, whatever, state specifically whether or not that writing is intended to be binding, or what in that writing is binding. Specificity. Number 3, be as detailed as you could be, concise, but as detailed as you could be with particularly bargain terms. Number 4, cross-reference previous deals if possible, cross-reference previous contracts, anything else cross-reference, incorporate by reference. It's important. It helps build consistency, and it helps keep the contract concise and short. 5, consider formulas. If you're unable to come to terms, consider formulas on how to come to these terms later on, especially things like with compensation and like bonuses and stuff. Number 6, always try to keep the contract as short as you can, short and sweet, but as detailed as possible. And then number 7, don't be afraid to use recitals. We mentioned this in the other video. Recitals are key. You don't need to use fancy pants legal terms. Recitals are cool. This guy intends to do this. This lady has a reliance on this, or whatever it is that you want. Okay, so this is episode number 3 of the L&E series, what we call here at Millennial Law as the fusion of law and entertainment. And as usual, we're always here to help you. There will be more content being delivered, so make sure you subscribe to the link below. Make sure you subscribe to the newsletter. Go to the website, www.millenniallaw.com, www.millenniallaw.com, and I once again forgot the title for this video. I will come up with some title at some point in time. Have a beautiful day, everybody. I wish you all the best. Yours in laws, love, and lifts. Have a great night.